My audio.
Doing great, thank you.
Is that my famous Steve Colby on the call?
I'm
Steve?
not the famous one. I'm the imposter.
Okay. Infamous. How are you? It's good to see you again.
Good. I had a joke, but then people told me I wasn't remotely funny.
Okay. Well, I think if it's coming from you, it's probably funny. Steve, do you remember when we met?
It was that dark and stormy. Never mind.
No, it was on the 22nd floor in San Francisco at the Pillsbury Law Firm.
Oh, really? I don't remember that.
Yeah, you and I were talking about one of the companies you were helping out.
Ooh.
The what's that called? The little icon thing.
Oh, was it a keyboard company?
Yes.
Virtual keyboard company? Yeah, that was a while ago.
Yes,
Yeah.
yes.
I should introduce myself. Hi, Jordan. My name is Rupak. We haven't really met, and I can't see your video, so.
Oh, I'm so sorry,
I
guys.
I do see your video, Jordan.
Oh, you do?
Everyone can see Jordan Rupak. It's because
Oh,
you're sharing your screen, that's why.
Oh, I see. Okay.
I see two Jordans, one with video and one without.
There's two Jordans. Is that me?
Yeah,
That can't be me.
I know.
Oh, there.
Interesting.
Yeah. Oh, now I see you. Okay, I just had to scroll down. Yeah, there are two Jordans for some reason.
How did I get in? Another way.
It
Kick that one out,
it's
please.
that cloning architecture
Yeah.
client that I have. Yeah.
It could be my Firefly. Can you remove him? Somebody remove him? Or him? Or her? Or it?
That would be Jennifer.
Or they?
You want me to remove?
The blank Jordan. Assuming there's none other Jordan out there.
No, that's you.
I can do it. Do you want me to do it?
Yeah, let me rename myself. So Jordan.
That would help.
No, the one with the video is clear.
Okay, here we go.
Perfect. Okay. I'll drop the other one.
Blank Jordan. Rupak, where are you calling from?
Oh, I'm in downtown San Francisco, currently in my office.
Awesome. Awesome.
Yeah. How about yourself?
I'm in San Jose, north of San Jose, right next to the famous 49ers stadium.
Oh, okay. Great. So you're in Santa Clara.
No, still San Jose.
Oh, still San Jose. Okay, got it.
The reason because I'm right at the very last house in San Jose.
I see.
Yeah. But Santa Clara, San Jose, it's all the same. How about you, Steve?
I am in San Francisco, which is somewhat rare. I'm usually in Reno area. But it's nice out of Richmond. It rained a bunch today, which back home is snow.
Or his home?
Stephen, do you live in Reno?
Yeah.
Oh, you do? Okay. I used to go there quite a bit, 10, 15 years ago when I did a lot of work for IGT. Their headquarters is there.
Mm. Yeah, we have an office in Truckee.
Hmm. All right, Jennifer, should we get started? It's 7 after.
Sure. Sounds great.
I mean, if
Well,
all the people are I mean, if they're all on Zoom or do you want to wait a little longer for some more people to show up?
We should start.
let's see here. Let me just do one final check if you don't mind.
Mm-hmm.
For those of you who I have contact with, I will attempt to help you see everything individually as we get going if you're still needing assistance. Okay.
Before we jump in, what are the dynamics of this? How do you want us to behave? What kind of walk me through what you want to see happen?
Careful what you say, Gene.
Ooh. So I'm going to give the official welcome and the official closing so everyone knows. Rupak is going to give the first presentation, and then we'll have a brief Q&A.
Roughly 30 minutes. Let's have time.
Total time for Rupak. And then we will hand it over to Dr. Colby, who will have his own slides presented, followed by Q&A. And then in the remaining time from there, about 30 minutes of open discussion. You can field from the chat or the Q&A box. So everybody here who is listening or watching, please use the Q&A if you want your question to be considered by the panelists.
Okay. And you're going to record all of this?
The recording is in progress.
Okay. Terrific.
Okay, looks good. All right, let's go ahead and get started. Okay, welcome everyone. I'm Jennifer, the CEO of ProVentures, and it's our mission to support and elevate startups. We're here to delve into the pivotal topics of intellectual property and valuation, which are crucial for the growth and protection of your innovative ideas. We've brought together a panel of experts to share their insights and experiences with you. And elevate at this time, I would like to welcome Rupak. Rupak, please take the spotlight.
Sure. Thanks, Jennifer. Hello, everyone. My name is Rupak Nag, and I am a patent attorney or IP attorney here in the Bay Area. Just a very quick background on myself. I started my career doing patent and IP litigation for 5 or 6 years. And then after that, I moved into patent portfolio management and prosecution. And that's what I've been doing for the last 15, 20 years. I've worked mostly at some large law firms and some smaller ones over the years, all here in Silicon Valley. I'm currently in San Francisco right now, speaking to you from my office. The last 4 years, about 4 years ago, I joined a Swiss tech company, and I managed their global patent portfolio, and mostly made up of cybersecurity, IoT, and digital TV innovation and patents in those areas. This presentation, first of all, it'll take about 30 minutes. I'm going to try to go through it and stay on time. It was something that I put together back in 2017, and it's a fairly unconventional presentation on patents. I've done others that are more conventional and more that talk about about patent law and the patent process within the patent office, and other topics. But I wanted to give a more interesting presentation on this topic, which can often get very bogged down, sort of legal, in the legal format, and of course, always very informative. But I wanted to give more of a narrative and a little different perspective into the patent process and what the reality is for getting a patent. And the other motivation for putting this presentation together was that I found that a lot of startups and founders, entrepreneurs, and even people on the business side or on the corporate legal side had some misconceptions about patents and how the process works, the costs involved, the time involved. And I was always a little surprised, and this is sort of things that I picked up while I was at law firms and working with startups and individuals, that they were often told many different things from patent attorneys. And I wanted to essentially sort of dispel those myths and misconceptions. Now, of course, everything they were told is not necessarily false. A lot of it has a lot of basis in fact. But I felt that the reality was being overlooked, and I just wanted to give a different perspective on into the sort of world of getting a patent from the filing to the to grant. So as you can see, it's called the unicorn patent, so a bit of an outdated name. Back then, there were unicorn companies, valuations over $1 billion. So what I thought I would do was take sort of the cornerstone patents for these unicorn companies and show the timeline and how they went about getting their sort of milestone or cornerstone crown jewel patents. And I just picked on those because I thought they would be more interesting, and they're kind of household names at this point. I do want to apologize a few housekeeping things that these slides are somewhat text heavy. I apologize for that. Next time I'll try to put some more graphics in here. And everything here is really my opinion, and other IP attorneys may have a different opinion on some of these topics. So, all right, I will go to the next slide. All right, first, just a quick overview of what I'm going to talk about today. First of all, the value proposition of getting a patent. Why bother getting one? What's the reason for it? And as I said, some common misconceptions that people have, the startup community in particular, and founders have about the process itself and the costs and the timeline and things like that. Improvements and new use cases. So this is something that's also comes up fairly often, because the technology for startups is always evolving, and there are new features, and sometimes companies pivot, or there are new use cases. So I want to talk about how to protect those, and also dispel some misconceptions about that as well. And then I'm going to just briefly talk about the 3 different types of patent rejections, and I'm going to sort of break them down into normal plain English for everyone. And then we're going to get to the core of the presentation, and that's the cornerstone patent prosecution timelines. So I'm going to talk about the cornerstone patents for X, Nest, Snapchat, and Instagram. And a little bit about one of the rejections. It's called the eligibility or ALICE rejection, which was a big deal back in 2017, or starting from 2014, and it still is. So I'm just going to get into that a little bit more for those who have software startups in particular. That'll be of particular interest there. So, and again, if you have any questions, feel free to jump in or put it in the Q&A, and I'll be happy to answer them at the end. So what's the value proposition of getting a patent? And this is something, what's in quotes here is something that I've heard quite often from a lot of startups, is like, we're a startup with limited time and limited funds. The reality is that we're not going to be suing anyone for patent infringement, and I hope you never really have to, because it's expensive and time consuming, and yeah, it's something you don't want to necessarily get involved in. So do we really need to get a patent on what we're doing? And it's a totally legitimate question. And I'm going to just provide 3 or 4 basic reasons for at least developing or building a small portfolio initially. And by small, I mean 2 to 3 patents, maybe even 1 or 2. First and foremost is really protecting your crown jewels, the core ideas. There's something there that you believe is novel or different, that you're going to build your business on, or you already have. It just makes sense to file at least 1 patent application to cover that core idea. And the patents that I'm going to talk about today, back when these guys were starting their ventures, decided that yes, we have to protect this core idea, and you'll see what I mean when I get to those slides. Stimulate investment, make it easy for investors and potential acquirers to sort of check that box that, hey, these guys believe they have something novel or something innovative, something worth protecting, and they're taking steps to protect it. And so IP on commercially proven ideas can be sold or used as collateral once you got some traction and some customers, or the company is doing well and your patents have actually granted at that point. They could be used for collateral, or you can sell them should it come to that. And if you're at that stage in your evolution of your company. You can use patents offensively to ward off blatant infringers. Now, while you don't really want to sue anyone for patent infringement because it's very expensive, but you do want to have, it's always a good idea to have a granted patent or even a pending application to ward off people who see that you're successful. They like your idea. Maybe the space that you're in is somewhat confined. And there are going to be other companies that come around and try to do what you're doing. So it's good to just have some IP that you can use as a shield or as a sword as needed. So, like I said, the motivation I had for putting this presentation, this somewhat unconventional presentation together, was to dispel some misconceptions that I saw in the startup community with regard to IP. First and foremost, I wanted to let you know that it's not as expensive as you may have heard to get that stake in the ground, to get that US patent application filed with the PTO. I'm not going to get into specific numbers here because it'll be different for many of you depending on your situation, the type of technology. But the numbers I was hearing from founders who are fairly sophisticated and from business people, the business folks who are supporting them, about the cost of getting a patent, quote unquote, were just off the charts, frankly. And I was just shocked at some of the numbers I was seeing, like $20,000, $30,000. It's nowhere near that to just get that stake in the ground. And if you have, I'm happy to speak with you off afterwards about what those costs could be. The timeline, it doesn't have to be 2 to 3 years before you actually get a granted patent or longer. There are options. You can take an accelerated track with an extra fee to the PTO where you can get a patent within perhaps a year and a half or less. For foreign protection, you can delay paying fees for that. And when some of the law firms quote the cost of getting a patent, sometimes they include the cost for getting filing in foreign countries and regions. But there are ways to delay paying those fees. You can wait to see whether your idea is doing well. Are you getting traction? Is the business growing? And then you can decide, okay, we're going to spend money on getting protection in Europe or in India or Canada, wherever it may be. And the last point here is something that I put in. I was going to take it out, but I decided to keep it in there. Back in 2017 and even before that, for software innovations, I didn't always recommend that people that they do a prior art search. And by prior art search, I mean like freedom to operate search or a state of the art or search to see what's out there exactly. I didn't think it was necessary at the time. I mean, because the founders that I was working with, they had the market industry research that they've already done, and they already know about their field. They know what's out there. So I didn't, and it was kind of expensive back then to do this search. But in the 7 or 8 years since then, the prices, the cost for doing a search has really dropped. So I have recommended to some startups recently in the software, internet, or e-commerce space that they do a prior art search. It's like $500, maybe $700, and you can get some pretty useful information. First of all, it could be confined to the US or it could be global. So I've sort of changed my mind about that a little bit. I think it could be helpful to get a prior art search. And again, if you have questions about that or need referrals, I'd be happy to give those to you if you're interested. Yeah, improvements in new use cases. This was another one that came up all the time with startups, and not surprisingly, because I mean, you've got an idea, and you file a patent, an application covering that core idea, but in 6 or 9 months, you've developed new features, or maybe you've added you've thought of other use cases where you're other markets that you think you might want to get into, other verticals, and I just wanted to sort of let everyone know that it's not difficult or really it's not expensive or time consuming to file what's called a continuing application, specifically a CIP application, which is, both of them are treated as separate patent applications. But what it does is it takes what you originally filed, the core idea, and you add new description, new content to that original content. And the new content basically describes the new feature, the new use case, whatever it is that, however the technology that you're working on has evolved in the 6 months or 9 months or a year since the original filing. It's affordable, and it can be done quickly. So I just wanted to let everyone know that you don't have to worry about not being able to protect other important things. I mean, you should only proceed with a CIP or a continuing patent application if you think that those new features are in fact innovative and novel. I mean, then it makes sense to file a CIP applications, for example. Okay, so here is my sort of plain language or plain English explanation of the rejections that you get from the patent office, because this is something that I would sort of explain if I had to tell my high school my kids who are in high school, hey, you file a patent application on your idea. These are the types of rejections you might very likely will get. Definitely the first two. So the first one I just called the bullseye rejection. And that is basically one prior art reference, one patent, one research paper, one document that the patent office finds that they say that they think is spot on and really just anticipates your invention, or the invention that's defined in the claims in your patent application. So it's kind of like the bullseye reference. The other, and that's fairly common, but the one that's more common is the second one. That's obvious. So the obvious rejection is when the patent office, the examiner, finds 2 or more references that they believe someone of ordinary skill in the field that your technology is in, that they would be motivated to combine these 2 references to come up with what you have come up with. And in that respect, it's obvious. And that's a term of art. It's a legal term. So, but essentially they're taking 2 or more references, combining them, taking features, say A, B, and C from one reference, features D and E from another, and saying that, hey, someone in this field would be motivated for efficiency reasons or whatever it may be to combine these 2. And if they did, they render what you've come up with as obvious. That rejection is very common. Not in the game is sort of your idea is not eligible for patent protection. And this is particularly true for software and internet-related inventions. It's too abstract. It requires mental acts. It's an algorithm, or it's just mere business steps. And none of these really fall into the categories that are protected by a patent. So keep these in mind. These are the rejections that I'm going to show you in the timeline, which is the first one here. Let me see if I can get that a little smaller. Yeah. So this is the timeline for X, formerly Twitter. And I'm just going to go through the rejections and how long it took without getting into the substantive things. Although I am going to show you the claims at the very end, so you'll get an idea of exactly what I'm talking about. So the founders of Twitter filed their first patent application for microblogging. It's a method for communicating from any type of device from one point to multiple points. And at the time they called it, yeah, I'm pretty sure it was called microblogging, the 140 word limitation. They filed that in August of 2008. They got their first rejection 1 year and 3 months after filing. It was a bullseye rejection. So Patent Office came back with one reference. They had to amend the claims. By amending, I mean they had to narrow the claims to get past that reference. They got another rejection, again, another bullseye. The Patent Office found a second reference that was that anticipated their idea. And then you can see there was a third rejection. This time it was an obviousness one. So this time the Patent Office had to come back with 2 or more references, combine them, and say, hey, these references make what you're doing kind of obvious. They got a 4th rejection, still obviousness. And then finally, after the 4th amendment, it was granted. So you can see at the bottom there, it took 4 years and 3 months after the filing for them to get their granted patent on their cornerstone core idea patent, and roughly 3 years of prosecution. And by prosecution, for those of you who may not know, that's just the time where you're going back and forth and arguing with the Patent Office. Yeah. Nest Labs, they filed their initial, one of their early patent applications back in October of 2012. This one was for the app that people had on their phones to control the thermostats. And specifically, this was the user interface and the user experience of that app, which was really innovative at the time. And again, I'll show you the claims at the end, but they had to go through a lot of rejections, as you can see here. So first of all, the first one came in about 1 year and 4 months after they filed. It was a bullseye reference. They got 2 of those, and they got an obviousness, 3 obviousness rejections. And I mentioned the number of references here, 4 references and then 5, because that's really stretching it for the Patent Office. When they start taking more than, say, 3 references and combining them to say that what you're doing is obvious, they're really reaching for straws. So, I mean, they're kind of stretching the viability of their argument, saying, okay, they couldn't do it with just 2 or 3 references. They had to get a 4th. And in one case, they had to get a 5th reference and say, you know, someone of ordinary skill in this art, in this field, would have been motivated to combine all these references together to come up with yours. So they got past those arguments or those rejections from the Patent Office, and finally got their patent after 3.5 years of filing and roughly a little over 2 years of prosecution. Snapchat, roughly the same number of rejections. They actually filed a track 1, which is the accelerated prosecution or accelerated examination that I mentioned in the beginning. And look how quickly they got it. So that it's not too expensive to file that. I actually recommend that almost all my the people that the startups that I consult with, that they file a track 1 request for exam. Because look, they got their first rejection within 4 months. The requirement is that the Patent Office then has to do it within a year. But from what I've seen, they usually come back within 6 months, maybe in this case 4 months, with that first rejection instead of 2 years or 1.5 years. And they went through various rejections. There was a bullseye, and these guys actually got an ineligible thing, so they weren't in the game. The patent office decided to do that. They should have done it in the first rejection, but they came back in the second one and said, like, you know what? We looked at this again and we decided that it's not even really eligible for patent protection. Like I said, it's possible. You're able to get over that if you make the right arguments and if you have enough technical detail in your spec in the patent application. So they got over it, and they got their patent after 1.5 years after filing. So yeah, that track one is always a good option, I think. Instagram, they got theirs really quick, but they had to wait a long time before they got their first rejection. So it took a little over 2 years. And then they got that rejection. It was a formality. They made some very light amendments to the claims and then got their patent. So that was 2.5 years from filing before they got their cornerstone patent. Now, I just wanted to briefly get into the not in the game rejection, as I call it, is basically the eligibility one that we were talking about, and it's based on a Supreme Court case from just about 10 years ago in 2014 called Alice, and it caused a lot of headaches for a lot of patent attorneys and applicants who were trying to get a patent on their software. Software was still patentable even after this Alice decision, but the Supreme Court said, you got to make it a really, we want to see a technical solution to a technical problem. And that's the language they actually use in Europe as well. They're very focused on, look, you have this technical problem, engineering problem, and you're coming up with an engineering technical solution to that problem. So what you have to do is just make it very clear in the claims that this is not an abstract idea. It's not a mere algorithm or mental steps. It's a real solution, engineering solution to a real world problem. So don't make the idea too abstract. Give it some technical heft. Make it a practical application, and then you can get it back in the game. But then you may have to still deal with the bullseye and the obviousness rejections after that. Yeah, just a little more about Alice, the eligibility rejection. If your idea is about automating or scaling, computerizing, quote unquote, something, you want to get your developers involved in the patent process early. Again, to give it that technical heft to the claims and to the application. For UX and UI type ideas, the same thing. Focus on the problem that you're solving. Oh yeah, and here's my glossary because I was using these plain English terms. A rejection is really called as office action. A bullseye rejection is a Section 102. Section 102 is from the patent statute. It's an anticipation/novelty rejection. They're saying that, look, your idea is not novel. Therefore, we're going to reject it with this one reference. The obviousness is 103. Eligibility is Section 101. When I say granted, it's really a notice of allowance that you get, and then you have to pay the issue fee, and it's then issued. And yeah, invention is really defined by the patent claims. Many of you may already know this. The patent claims are these long sentences at the end of the patent application or at the end of a granted patent that define the metes and bounds and the boundaries of exactly what your invention is. And that's what it's those patent claims that the patent examiner looks at and really focuses on. So now I'm going to, with the last few minutes I have, show you Twitter. So on the left are the claims that Twitter that the founders there filed right when they started their company, or when they started Twitter back in 2008. It's published claims, but they're very close to the claims that were initially filed. You see how it's relatively short. It's got 1, 2, 3, 4, 5 steps. But through those amendments, I think there were 4 or 5 amendments to these claims. On the right is the actual granted or the issued claims, the claims that were in the patent that eventually granted it. And see how much longer it is? There's a lot more detail in there. It's a lot narrower than what they initially filed. I'm not going to go into all those, but I think they're roughly like 10 steps now in this method. But, you know, it still protected their core idea. But I just wanted to give you an idea, a visual. You can get a visual of like how the claim has changes from when you file it to what's actually granted. Here's a Snapchat claim, again on the left, what they initially filed, the ephemeral message to an ephemeral gallery. And you would think that would be pretty narrowing in and of itself, that language, because that's unusual language to see in a claim. But even they had to amend their claim significantly. And that's the claim that was allowed at the end. And in this case, they didn't have a method claim. It was a server that carried out these, or had these components. And let's see. Instagram actually got theirs very quick, and they didn't have to make many changes or make amendments to their claims. These are roughly the same because of the formatting. It looks like the initially filed claims are longer than the granted ones, but they're generally the identical. I think they got this because they had some very specific language about blurred image version, BIV here, which the patent office probably had a hard time, finding prior art on. So. And finally, Nest, the user interface method used on a computer device, like a smartphone, for accessing one or more thermostats connected to a network. So this primary enclosure, for example, is a room. It could be the living room. I'm sorry, actually, that's probably the house, and then there are one or more enclosures within the house. But I mean, their initial claim was pretty long, and but what they eventually got went on quite a bit. It's a very long claim. And this is, and again, partly because this is a user interface patent that protects user experience and what people saw on their phones. But I mean, they managed to take this and build a company, very successful company out of it. So that is all I had for today. Like I said, it's a rather unconventional presentation on patents. I hope it was interesting and gave you some insights into the process that you may not have gotten from other presentations on the same thing. If you'd like to contact me, I'll just put my email is on the first slide, but I am now open to questions if there are any from the audience.
Could we have our panelists back on camera, please?
Yeah, I know that maybe there are some in the Q&A box.
And remove your slides, please, Reebok.
Oh, stop. Okay. Yeah, let me stop sharing. Hold on. Sorry. I'm trying to stop sharing here. Can you just give me a second to figure out how to get rid of that? In the meantime, you can look at some of the questions if there are any.
Yoshi was able to get some seed during this presentation. If you did see that, congratulations to Yoshi.
Avatar, choose. Hide self view, change. Sorry, I'm trying to get to the part where I can stop sharing, but
So
no trouble getting there.
Jennifer, can you guide him through it, please?
Sure. Let me see if I can just stop it for you. Dr.
Yeah, maybe we can
Colby.
stop it because what I am seeing here, I don't see the icons at the top that I
That's
normally
okay.
see because I think I
I'll,
hid them
I'll take care of it.
and now I cannot unhide them. Thank
I did
you.
it.
Great.
Please forgive me.
No, that was my issue there.
Okay. Thank you for that.
Sure. Yep.
I'm looking at the Q&A and seeing if we have any on-topic questions here. At what point patent application gets published or gets accessible by the public?
Yeah, good question. So 18 months after the initial filing, it's called a priority filing. And there are some nuances there depending on whether you file a provisional patent application or a regular one, but essentially 18 months. I'll just give you the simple answer.
Okay.
It publishes, and so those claims that you saw that I was showing on the left, those are the published claims. They were very similar to the claims that were filed initially.
Okay. Are there any templates available? And could you touch upon the best approaches for incorporating trade secrets?
Okay, templates for what exactly? You mean for a patent application?
Yes.
Not really. I mean, there's a format, there's a structure to all patent applications, US ones, but not a template, because the danger with that is, I mean, you have an innovative idea that's novel and different from other ideas. And you just have to be able to describe that and in some detail in the patent application. So not a template, but certainly a structure to the application itself. And so I guess yes and no. I just don't, I'm not sure about the word template, but there is a structure to a patent application that's pretty uniform. It's just filling it in is totally dependent on your invention, your idea. So, and sorry, what was the second question was what? Trade secrets?
Yes. Would you like to touch on incorporating trade secrets?
Well, generally, I mean, trade secret, because the idea of a patent is that you're telling the public your idea, you're sharing it with the public, right? And that's the opposite of what you want to do with a trade secret. The trade secret should not be talked about or described in a patent in the spec of a patent application. It should just be kept as a secret within your organization or your startup. Yeah, two different things. The patent office deals with patents and trademarks. Trade secrets has to do more with state law, although I think there's now a federal trade secret act as well. No, there isn't. So
not really.
no, okay. So it's a state law, and if you have a trade secret, keep it secret. Don't put it in a patent application. That's my simple answer for that or response. And Stephen could maybe elaborate on that later, or at some point. But
Okay, great.
Yeah.
Two of the same question. Can we define not too expensive? Thank you, Charles. And Dimitri, what is the rough cost of expedited patent filing?
oh, so the track one, oh gosh, I think it's about $1,800 or $2,000 is the fee for track one. Yeah, and the filing fee for a small entity like for most startups is close to 1,000 roughly. So it's you are tripling the cost of the filing, but I think it's worth it, especially if you're in a field that's moving fast. And those fees are, you can find out what they are from the patent from the PTO website or doing a quick search. Yeah.
William asks, of all revisions, what is the breakdown from must revise to desire to revise in your experience?
What's the breakdown from? Sorry, repeat the question again, Jennifer. I didn't.
Must revise to desire to revise.
I not so by revise, do you mean amend the claims, or I'm not sure what they mean, what the term revise is referring to exactly.
Yes, that's correct. Must make a change versus want to make a change.
Oh, okay. So, revise is, so I was calling it, it's called amending the claims. So, you amend the claims during prosecution when you have to, and only when you have to. If you think that the references, the bullseye reference or the obviousness references are strong enough and you can't get over them, you can't overcome them rather, by simply arguing that your invention, your claims is different from what's in the reference, that's when you have to amend, or as the person's putting it, revise the claims. The term they should be using is amending the claims. That's when you have to do it. Otherwise, you're just going to be deadlocked with the patent office, and you can appeal, and there are things you can do. But so the short answer is it depends on the strength of those references.
Mm-hmm.
Are they good ones? Do they really come close to what you're trying to claim?
Mm-hmm. Okay. Jim asks us, how do you defend against obviousness rejection? What if something was tried back in the 1980s and didn't? And there's a large body of literature saying why and to do other specific things, but suddenly in 2021, a change in underlying technology caused it to start working better than anything else, but nobody in the field noticed. How would you buttress that?
Okay. Well, so two things that come to mind that I'll just put out in response to that. One is the obviousness rejection. If the patent office, the examiner starts combining too many references together to say that to get the features that he or she needs to show that what you're doing is obvious, you can argue that there isn't really motivation to combine those references. The trickier question he's asking is something that was tried back maybe 10, 15, 20 years ago and is now someone has come up with a different way or a way of doing it. So hindsight, in short, you can't use hindsight with respect to obviousness. So you can't, the examiner cannot put herself back in say the late 1980s and look at the claim and say, well, this is obvious, looking back at what we knew in the late 80s or 90s or whatever, like years ago, cannot be used to make an obviousness argument today. So hindsight is not allowed. And that's, most examiners know that. They won't try to do it, but if they do, you can argue around that type of obviousness argument or rejection, rather. I think that answers the question. I mean, it sounded a little more involved, but I'm happy to talk to the person asking that question offline if they like.
Yeah. Andres.
But yeah, in short, you can't use hindsight. hindsight's 2020, you can't use it for obviousness, rejection.
Okay. What do you think about crowded inventing and crowdsourcing?
Uh, crowd, crowdsourcing and crowd what? Crowd inventing?
Inventing.
Uh, I don't know. I haven't given it much thought, but I will say this. I think it's fine if people who don't know each other come together and come up with an idea and they want to patent that idea or that concept. It's just important to name all the inventors. So that's one thing I didn't really get into very much in the presentation, but any individual who contributed anything to a claim, to a patent claim, those things I showed at the end, is an inventor. So if you're going to crowdsource an invention, just make sure that that patent application lists all the people who contributed to the claims. And that's really, that's the important thing, because that's a legal thing. It's not a business matter. It's a legal requirement. And the second thing is you got to figure out who to assign that patent to. I mean, typically founders or engineers, they assign, after everything's filed, they assign the rights to the patent to the company. So with crowdsourcing, I'm not sure, they would have to come up with a company, an LLC or something like that, a partnership, and assign the IP rights in that patent to that partnership. It's generally not a good idea to have 15 or 10 different inventors owning a patent. Each one gets full ownership. Basically, they can do what they want with it, and it's a mess. So, but otherwise, I say go for it.
Okay. Another question from Andres. Is it possible to patent methods that are based on already patented systems of other organizations? For example, methods that work on LinkedIn, WhatsApp, etc.
Well, it sounds like if you tried to do that without making any improvements or coming at it from a different angle or perspective, you're just going to have a prior art problem. I mean, you can file the patent application, but I think the examiner is just going to find lots of references, those bullseye references that I was talking about, to reject the patent application. So it sounds like what the person asking the question is describing is something that's not novel, unless they're putting their own spin on it, right? And coming up with an improvement or something different that what LinkedIn or that other company is, whatever other company is doing. I hope that answers the question. Yeah.
Okay.
Again,
Last question.
yeah, I just want to say, anyone who's asking questions and I'm not fully answering it, or you want to get more detail, feel free to email me or reach out. My email was on the slide there, but maybe you can provide it again in case people didn't get it.
Okay. Let's do one more, and then we'll find out if Dr. Colby or Jordan has any questions for you before we move on to Dr. Colby's presentation. Okay, this is a little longer, and it's, what do you think about the possibility of discussing the way in which data processing systems or methods are patented, considering that they should be adapted to current agile methodologies and not to the waterfall development as before? At least the priority date should be protected while a product is being tested to patent if it works. It is discussion that we should escalate to WIPO and USPTO. What do you think?
I'm not sure if I have an opinion on that. I can you just repeat the first part of that again? Because
Sure. What do you think about the possibility of discussing the way in which the data processing systems or methods are patented, considering that they should be adapted to current agile methodologies and not to the waterfall development as before?
I'm not aware of if there is a discussion going on about that, but I mean, the patent office is pretty, you can certainly submit questions like that to the patent office and they will respond. I mean, if you wanted to start a discussion on that, it sounds like it's a fairly specific or narrow topic. I think they're fairly open to talking about things like that, and WIPO as well. They have forums for that. But with respect to the specific thing that is being asked about the agile systems and data processing, I'm not sure I can answer that off the top of my head. But the patent office is constantly evolving or addressing, new issues that come up in technology that affect patent applicants. I mean, a couple of weeks ago, they came out with with guidelines for AI, for example, in respect to who is an inventor, who can be an inventor with respect to if AI is involved in coming up with an idea or an invention. So, I mean, that's just one simple example. It has to be a human, by the way. That's a short answer. But yeah, sorry, I don't really have an answer to that specific topic with regard to data processing and agile systems.
Okay, this is the official last question we'll have for Rupak from the attendees. Dimitri says, can a co-inventor be excluded from decision-making as far as what to do with the patent, or do all co-inventors have equal 100% rights to the patent by virtue or being included in the patent?
Yeah. Okay. So this was the crowdsourcing question. When I answer, I brought this up when I respond to that question. Basically, the inventors to a patent, they could be 2, 3, 5 or more inventors. It's always good to assign the rights to that patent to a company or to a legal entity. And so at that point, when it's assigned to them, assigned to a company or an LLC or a partnership, those co-inventors no longer have rights as to how that patent's going to be used. It's the corporate entity that decides how it's going to be used. Now, if you don't assign to a corporate entity and you just have like 3 people or 4 people who contributed to the claims or co-inventors, then yeah, each one has the right to do what they like. I'm simplifying here, but they have the right to exploit that patent as they like. And I think there may be a requirement to let the other co-inventors know what they're doing with it, but I don't think the other co-inventors can't stop that one inventor from exploiting that patent. I hope I'm getting that right. Maybe Stephen can clarify that when at some point. But it's always good to assign the rights to the patent to an entity, to the startup, so that those co-inventors, because one of the co-inventors could leave, right, and go to a competitor, and you don't want that person to have rights on how that patent's going to be used. So the assignment is done almost always at the time of filing, because you don't want that loose end sort of out there. I hope that answers the question.
Thank you. And that concludes the questions we'll take for Rupak from the attendees. Stephen, if you want to load your slides, and in the meantime, Jordan or Dr. Colby, if you have any questions for Rupak before we have him mute.
How much time do we have?
Let's just give another 2 minutes.
Rupak, Jordan, Silicon Valley Venture Group, we do investments across the board, and one of the key things is these pesky patents.
Yeah, they are pesky sometimes.
Immigration law is a difficult one. Some other elements in the law are very difficult, but they're getting automated or somewhat guided through some back office, some software intelligence to guide the novice person like me through the different steps.
Mhm.
How how much of an advocate are you for simplifying the front end in terms of applying, reviewing, assessing, and getting a lot of the work done up front, such that when they land in your doorsteps, they're 20, 30, 40% baked?
Yeah, I am an advocate of the inventors doing uh, contributing to the drafting of the patent application and making it more collaborative. First of all, it saves them money and they get more involved in the process. Now, I don't know if they should do it before they show up at my doorstep. I think it's I've always had inventors and the engineers sort of work with me when it comes to drafting the patent application, the claims, and the figures. Some of them don't want to, and that's fine. But I think it's good when they do. They save, again, it's a financial thing. They save money. They save me time, and yeah, so, but what? How much work they do before they get to me or to any a patent law firm, for example, that I don't want they shouldn't they may not know exactly what to do, right? That would be useful. So it may not be the most efficient use of their time, but if directed by someone who is familiar with the process and has done, dozens or hundreds of patent applications, that person can tell those people, the engineers, the co-inventors, hey, this is what I need from you. This is how much work you can do up front to save me time. Yeah, no, I'm an advocate of that. A lot of law firms don't like it when inventors do that, or they don't want to get the inventors that involved with the drafting and actual um, preparing of the patent application. But
Got it.
I'm an
Second component is, as we look at companies, IP plays a significant role in the valuations of companies. The biggest challenge is, and I'll say that humbly, just about every third founder comes in with a patent in tow just to qualify and do a checklist. These patents may or may not have some value, may or may not have some impact on the company's valuation. The company's
Yeah.
value based on the IP is very tricky. So, in the capacity of a law firm, is that something you can give them guidance on, or is it strictly in the mechanics of filing for a patent and securing?
Well, it shouldn't just be the mechanics of doing it. It's not like a trademark or a copyright. So the patent attorney or the law firm, they can give guidance. I'm trying to figure. Well, at the end of the day, whether it's someone like you, Jordan, or whoever the investor is, and the co-founder is coming in with one or two patent applications that they filed, you have to look at the quality of what's been filed, right? And the quality of what's been filed can be determined fairly quickly by looking at the claims and seeing, like, taking the claims and mapping it to what their business model is and seeing how much of a correlation there is between the two. And then the investor, or the VC, whoever it may be, can make a more qualitative judgment or determination. Is like, okay, is that patent that you filed, is it really worth something or something that we should take into consideration? Or is it just something that you do to check the box? Now, I know I used that term check the box in my presentation, but I was assuming that they were filing quality. I'm assuming quality patent applications where the claims map very closely to what their business model is or what their innovation is.
Okay. I will
Yeah.
defer to Mr. Colby and his smarter questions.
Oh,
Okay.
those are good questions, Jordan.
Yeah. So you gave some examples of patents that were, the core patents for a bunch of different companies. What do you think made those patents really valuable? Or were they actually key to, Nest and
Yeah.
the X social media?
That's a good, okay, so what made them valuable? I would have to go back and look more closely at the well, I would have to do a closer correlation between the timeline of when those patents were being prosecuted and how Twitter or Nest or Snapchat were growing at that time. So were they getting a lot of traction? Were they getting investors? Um, I I feel like psychologically or mentally that the co-inventors or the engineers, uh, the people who filed those initial patents, psychologically, I think they needed to do that to feel like they were protecting their core idea. But it was several years in most of those cases before they got their granted patent. And as you can see, as you saw, the claims were quite narrow and long. And how much, but I still think those narrow, long claims still protected their core idea, just a lot, they were just a lot more narrowly so. Uh, but it's a tricky question. I mean, a question that it's interesting because if you go back and you look at the timeline, say for Twitter, right, 2008 to 2012, I believe, was the time frame of when they were prosecuting their patent. It'd be interesting to see how quickly the company grew during that time, what kind of investments they got, or what was happening with them exactly, and map it or do a sort of correlation to how the patent was being prosecuted. But I don't know. It's an intangible thing, right? To know whether the patent actually contributed to their business at the end of the day. But it would be an interesting exercise. I guess that might be the next step for me to do something to carry out an exercise like that.
Steve, any other questions?
No, I'm good.
So, Rupak, quick
Mhm.
question. It's
Yeah.
expected. If we don't ask it, they're gonna throw tomatoes and rotten eggs at us. Are you ready?
Oh,
The AI thing. I can ask
yeah.
any questions and put the word AI in it and creates So is this AI thing affecting your patent
Well,
process?
there are a couple of small company startups that are using AI to help draft patent claims. So, yeah, I mean, it hasn't affected me personally, but I've seen them at a few conventions or conferences where, yeah, they take the spec, they take the description of the invention of how it works,
Yeah.
the innovation, and they, as far as I know, they try to draft patent claims based on that.
What guidance do you have for the inventors and the founders and the investors related to an AI screen review touch type of application or process?
Uh, oh, you mean using AI to draft the patent application, or the innovation itself deals with AI?
No, using the AI to
AI.
draft
Oh,
applications and process.
well, okay. I mean, I think the founders, the innovators, inventors, they should bring it up if they're curious and wondering how it could. They should bring it up with the patent agent or the patent attorney that they're working with and say, look, one way we might want to try to save money is like we're interested in using this new tool, and I wish I can remember the name of it, in drafting the patent claims, and so that you, patent attorney, spend less time on this application, and we, the inventors, can contribute more to getting this thing filed. So the short answer again is yes, I think they should bring it up. Why not? And if the patent attorney the professional is not open to using that or thinks it's a bad idea, well, then they can decide what to do. But I know that it's becoming more prevalent.
Any concerns about quality?
Well, okay, so yeah, so I should have finished my thought there. At the end of the day, the patent attorney, together with the inventors, has to review the patent claims and make changes, because AI is not going to put the nuances and use the right language all the time. I mean, so it's just a starting point, but it's a starting point that saves some time. But at the end, it's the patent attorney who has to approve the claims and decide what makes sense to be filed.
Thank you, sir.
Yeah.
Thanks for your presentation. Really learned a lot today.
Oh, thank you. Yeah, I'm glad. I hope the audience found it interesting and different from most other presentations on this topic. So,
Yes, thank you, Rubahawk. And at this time, we'll turn it over to Dr. Colby. Please take it away. You have
Oh,
the spotlight.
right. Wait, let me just double check. Can you hear me? Yes.
Yes,
Okay, great.
I can.
So I am going to talk a little bit. I'm going to focus more on the value part of what we are discussing here today. And I do a whole series of different webinars on a regular basis. And what I've done for this presentation is take some of my slides, kind of cobble them together, focusing on specifically the value and the value point. So when I meet new clients and inventors or people founding startups, I start off by asking them the straight simple question: why do IP? Right? You are a cash limited startup. The amount you spend on a patent attorney could hire, another engineer or a business development person to get your product launched. And the question is, why would you want to do this? And the answer is the valuation, right? That is, for early stage startup, pretty much the only answer. I have one patent litigation case right now, and it's in its 7th year. Can you imagine being an early stage startup and spending 7 years trying to prevent a competitor from copying your product? That's just not going to happen. If you are a startup and you start litigating patents, you have turned into a patent enforcement company and you won't have time to do anything else, right? And what most of us want to do, and what most of the investors want, is a company, right? They don't want a patent portfolio that's just going to be set out for licensing, because that's not as attractive a business model for them. In general, for the investor, there is more value in a combination of a business with a patent portfolio than just a patent portfolio itself. That makes it hard to be just an inventor. I do know people who are professional inventors, and I know organizations that help them. And they make products that I see in Staples and in Home Depot. And they can make good money. And that's kind of a different audience. If you are that type of person, reach out to me and I can refer you to advisors who are experienced toy inventors who've started organizations of inventors that help each other out. I'd be happy to send you that. But for a startup that is a Silicon Valley type, I'm going to take angel or VC money startup, the reason that you are going to do IP is to increase the valuation. For Repak and I, if we do our job right, every time you raise new money, we pay for ourselves many times over, right? If we can build enough, make that, and I'm going to use the same phrase that everybody else has been using, and it's in my slides, you'll see, make it more than just a checkbox. You can actually add significant value to your company. I've had, in the last 25 years or so, I have had plenty of clients where the IP made the difference, a big difference in their exit. And in a couple of cases, it actually made the difference in which company got bought. And the one with the better patent portfolio got a lot of money and the other one just went away. So let's talk a little bit about how to make your IP portfolio more valuable, all right? So the first thing is you really have to have a strategy, okay? The patents are for the marketing people, not the engineers. I'm going to say it again, not the engineers, for the marketing people. And this means, what is a patent? It's the right to exclude somebody else. It's the right to say either to your customer or to your next investor, we're the only people who have the rights to X. Okay. And those people in their mind should go, oh, I've got to listen to this company. It's got a feature, right, that I really want to have. So if you have a product type roadmap, you also want to have a patent roadmap that's going to follow along in the product roadmap. And your patent strategy should be, okay, this is our minimal viable product. Let's get that covered first. Then these are the features that we think are really going to be most valuable to us. Those are the things that are, I had a boss who used to call it the silver bullets. Trying to figure out another phrase for that, but yeah, the silver bullets. And those are the things in your pitch to your investors that you say, we're going to be number one. We're going to be a unicorn. You should invest in us because we have blah, blah, and blah. Okay. Those are the magic things that's going to make your company super valuable, you hope. Okay. Well, those are the features. The technology that supports those features is what you want your patent applications on. You don't want what the engineer thinks was really cool. You want what the marketing and sales guys think is really cool. You want the thing that's going to open the zipper to your investor's pocket. That's what you want to do the patent on. Okay. And my phrase here is make IP more than just a checkbox. Okay. This is exactly it. You want to have it be something that relates to the value of the company. So when my clients get to like maybe their A round, right? They've built a portfolio, they're a couple of years in, they have maybe some issued patents and stuff. If we've done our job right, it really starts to get traction. It can make a difference. And I'm going to show you a slide that I give to my clients. I put this together for them for free, right? When they do their A round, it's kind of like the after building a ship, you get to break a bottle of champagne as it runs out, you know, as you launch it into the water. To me, this slide is it when I know I've delivered, right? And sometimes I've done this at stages, you know, a slide like this for the exit, okay? And when companies are coming, why should we buy you? Give us a list of your patents. I give them a list. I give them an analysis of why each patent is really important, and I give them this slide which starts it off. So this is an example, and I didn't invent this. One of my old advisors did. It's called a cluster map. All right. This is a real client. You can look up these numbers. These are real patents. And this company did image processing. They were a very early player in take an image and tag it. Okay. It turns out this company is really valuable now because of they have about 750 million very well tagged images, and they have the best data set out there, right? So other companies, I'm not going to name who, but other really big companies in the AI space are clamoring to them because they have the best tags. They have the best descriptors for the images. And at the time this slide was first made, it was probably 10 years old now. There was three features that they were talking to, or four features that they were talking to their investors about. Being able to prioritize images. If you're going to spend server cycles on processing images, figure out which images are most important. All right. So it turns out this company can go through a social media feed and pick out the images that are going to be most relevant to process. They will tag those images, and the tags can then be used for advertising, and they can more than double the click rate of ads by doing this. Okay, so image prioritization. All right, selecting which objects in an image in multi-processing stages was something. Distributed processing. A lot of the processing that they did started on cell phones, so they don't have to pay for the service. These are all, you know, and I got my little window over the fourth one. What was it? Yeah, speed and quality. So those were the silver bullets that made their company really successful. In their presentation to investors, they finished their discussion of why they're so successful because of these various things that they're best at, right? And then they throw this slide up. Okay, here's what our patent portfolio looks like, and here how it relates to the things that really are making our company a success. Okay, this was first introduced to me by, I have to give credit, John Farrell of Carr and Farrell, where the first law firm I worked at, you know, first introduced me to, I don't know if he invented it, but he first introduced me to these cluster maps. This is an example of how to make the IP more than just a checkbox. At this point, you've actually conveyed a lot of value to the investor, and boom, your argument of why your valuation should be 20% more than the investor thinks just had a lot of support go by it. So this is an example of what makes a patent application valuable. When Jennifer and I were first talking about this, this subject, I get people coming to me all the time saying, "I've got a set of patents. What are they worth?" Right? I have seen patents go up on auction and not sell, and then go into litigation and produce, 40 times more revenue than they would have. So somebody could have bought them and used them, right? The value of a patent is really dependent on how it matches what the company's doing. I mean, the value for a company, right? It's hard, therefore, to take a patent off the shelf, and try to sell it to somebody, because it's like finding your significant other, right? One person's fairy prince or princess is the other person's ogre, and if you're the guy from Shrek, you want the ogre. I mean, it's a match. You got to match the right combination. Okay? And so people ask me, "What's this patent worth?" And I can say, "Well, this is a really narrow patent, or this is a really broad patent." It depends on so many details about both parties in the transaction. That's really important. So what you want to do, if you are doing an early stage startup, is you want to think about why people are going to invest in you, why your company is going to be successful, what tech supports those features, and that's what you want to patent. If nothing else, take that one statement home. Okay, that's how you do the valuation of a patent. Okay, now we've done evaluation. Now I've got some other slides. What can you get as a startup? Don't forget copyright, trade secrets, and trademarks. Okay, these are much less expensive, but they can contribute a lot. Trade secrets are, we discussed a little bit earlier. You want to have them. You want to document them, though. A trade secret that's well documented and part of an actual trade secret program is much more valuable than one that isn't documented. So ask your patent attorney, what kind of trade secret program can you set up for me? And that means like a 2-page description of the trade secret and controlling access to who gets to it. Not everybody in the company gets to see the trade secret, right? There's some oven that heats some metal to a certain temperature before you bend it. That's a trade secret. And only 3 people in the company get access to that. They've all signed a little statement saying they realize they're getting access to a trade secret. You have a description of it that you keep in a secure, safe place, either digitally or in physical form, in a safe, okay? Copyright and trademark, we can do entire seminars on those things. But keep in mind, whatever you're getting, the goal is to increase your valuation, right? So that when you sell your company, you get the most out of it, right? And I have seen some cases where the IP portfolio of 2 different companies meant that one got bought and the other didn't. And the one that was bought was for several hundreds of millions, right? And the other company just went away. And that was part of the deal. One of the differences in that case was the timing. There was just a couple of weeks difference between the filing of one company and the filing of the other company. So when do you need to start talking about IP? Before you even talk to investors. The patent attorney is one of the first people you should talk to. If you have co-founders, you need a co-founder agreement and you need a patent attorney. Okay, those are the first 2 things that you should put in place, right? And you probably need you may need an employment attorney if you're doing a solar technology and you're leaving a solar company to do it. That's the 3rd thing you absolutely need to have in legal size if you're fine. So start early. We are getting kind of late here, so I'm going to go pretty quickly. We talked a little bit about costs, and I'm going to give you actual costs. I do a flat fee program for provisionals. It's $2,500. Okay. And if you don't have that money, you should save a bunch of money, because if you're going to do startup, you need to have some cash. Okay. A non-provisional application does cost in the tens of thousands. 18, 20,000 is not unusual, but that will go down as you grow your patent family, because you'll reuse specifications. So probably on average, a good non-provisional application to get it on file is probably going to be $12,000, $9,000. But the first couple will be really important, and those are going to cost more. I tell people that getting a patent application and hiring a patent attorney is sometimes like buying a car. You can get a Yugo, which will be really inexpensive, but won't go very far. You can get a Jaguar, which, oh, in the days I used to first tell this story, Jaguar wasn't owned by Tata, but in the old days, you could get a really expensive Jaguar and it wouldn't go very far either. But then you can get a good Camry, right? And a 2002 Camry is still going. So, and it costs about, back then it cost about the same as a patent application. So it's this. I have to evolve that story, but
and you can't forget about the Yugo. Nobody knows what it is anymore.
It's a car. Yeah, sorry, I'm old, right?
That's all good.
So, I have another story here. The first job I got, so I spent most of the 90s as a CTO of a chemical instrument company. And I was doing patents, and I went in, I worked with this patent law firm called Carr and Farrell, which is still in Menlo Park, great outfit. And we were talking about inventors writing patents, and so I'd written this patent, and they liked it, and we were going to do the filing, and then at the end of the meeting they offered me a job. So this is how this happened. Let's see. I'm going to go back to some of the other questions. AI is at the point where it's actually really useful for proofreading. So I am actively using AI tools to proofread patent applications now. I am experimenting with rewording of paragraphs using AI. There's some really good tools out there. I'm not ready to announce like who I'm going to use, because I'm still exploring different vendors, but I've been pretty impressed so far. So actually, after this meeting, I'm going to go play with one of those tools, see what happens. Okay, let's move on. I know it's late. Everybody wanted to go. So ownership. This is another thing. I have a whole talk that I give on the 5 big mistakes you can make, right? And ownership is 2 of those mistakes. I have one of these. I've got 2 of those slides from that seminar right here. Ownership starts with the inventors. If you don't have an agreement with the inventors, or even if they're employees, it depends where you are in the world, right? The law in Spain is different than the law in the United States, and I'm not a Spanish attorney, right? I am a US patent attorney. So you need to talk with somebody local to you. But in the United States, ownership starts with the inventors, and you need some sort of agreement. So all your employment agreements, even if it's a sales guy, should have some invention assignment clause. My favorite story here is Adobe Forms, right? We all use Adobe Forms. That was invented by an Adobe salesman, right? Great product. They're in touch with the customer. They often come up with the best ideas. So you have assignment clauses in agreements with contractors. You have assignment clauses in all your employee agreements. This is a matter of state law. So you are going to have a little bit different in Florida versus California, right? So you need to have a IP attorney look over your employment agreement to make sure it's working in that state. I'm going to skip one, so I'm going to have to have that. But there's an assignment process. There's a registration process. Just like when you buy and sell a home, there's a county recorder. The USPTO records ownership of patents. So even though you get an assignment in your employment agreement, you really want to get a separate document signed by the inventor. That document gets filed in the USPTO as an assignment, and eventually it becomes a public record. Okay, so keep that in mind. These are all. I do. If you send me at the end, my last slide has my email. If you send me a note, I will give you a link to some of my other presentations. Jennifer is going to be hosting another. We've got another one coming up in a couple of months. So attend, and you will see. I will dive deep into these types of things. Okay, moving on. A couple more slides. Okay, other people's IP. I'm going to talk for. Okay, give me 2 minutes on this. If you work for a big company, if you work for Intel, perhaps, just by way of example, they would discourage you from looking at patents because that can increase the liability of Intel if it infringes. If you're an early stage startup, I think the situation is reversed. You want to know what's out there, right? You are at the point now, you're not Intel, you can change your product roadmap, you can do a pivot, you can work around other people's, engineer around somebody else's patent. So being, a scientist, having come from the sciences, I encourage you very much to read the literature. This means read about all your competitors, all their blogs, all their websites, their product announcements, go see their presentations, and read their patent filings, okay? So a patent in the US usually, but not always, publishes in 18 months. You can keep it secret until it actually issues, but that means you're not allowed to file outside the US. Read the literature, keep lots of notes, right? If you have a meeting where you discuss inventions, and you write notes down, that could help you in figuring out 6 months later who the inventor was. It could help establish that an idea came from employee X, not employee Y, who you hired from a competitor 3 months later. And in a trade secret litigation, those notes are priceless, right? It'll save you hundreds of thousands of dollars. So be aware of other people's IP if you're an early stage startup, okay? And talk to your patent attorney about this approach, okay? 1.5 slides left, okay. Ownership, all right? These are the 5 mistakes I see early startups making. Ownership of your own IP, ownership of other people's IP. You don't want to have your employees bringing other IP into your company, right? That can be a problem. Waiting too long, we released 12 months ago and we've really got traction, so now we'd like to go after patents. It's too late. Sorry, you're in trouble. Right. We talked already about strategy, and again, I have a seminar that just goes where this is basically the outline. The strategy IP needs to be more than just a checkbox. All right, that's what you're going to remember. Okay. Understanding the patent. I have a seminar coming up later this month. I think it's on the 19th, where I'm going to do a deep dive into the anatomy of a patent. Right. You kind of got little hints from people about a specification and claims and how a patent application could create a family, that's priority claims and so on. I'm going to go into that in detail. This will be a technical, from a legal standpoint, I'm going to go into a deep dive. And that seminar is going to be designed for people who want to really understand it so they can communicate with their patent attorney when they see somebody else's patent, not to freak out, but appropriately, okay? So those are the 5 biggest mistakes I see. And I'm now going to put my last slide up. Boom, ta-da! I work for Ramon Law. We are about 220 attorneys. We do everything startups could want, lots of countries all over the world. There's about 20 of us who are patent prosecutors, and that means we write patents. There's about an equal number of patent litigators. We have some really big, well-known patent litigators on our team. So as I said, about 5% of my work is patent litigation. Feel free to connect with me on LinkedIn. I'm easy to find. And now, Jordan, Reepak, Jennifer, questions. Let's do it.
Okay. Wonderful, Dr. Colby.
That was quick, but yeah.
Always exceeding expectations. I hope that Yoshi can be quiet enough for me to read a question. There's only one from the attendees, so I am going to be brief here. And how does a group of engineers and inventors protect against making the same thing that unknowingly is already patented? Is there a discipline of searching that should be done?
Yeah, and you can search. There's a book actually by Nolo Press on how to do patent searches. My recommendation is you start with your own search and go and see what your competitive landscape looks like. Start with Google Patents. Start with the web, just with Google, and look for what other people are doing. There is an issue that if somebody has filed a patent application a few weeks ago, it's not going to publish, for maybe 18 months or maybe longer, right? So that's priority against you already, and even the best search in the world isn't going to find it. If you want to do a prior art search, the examiner is going to throw a Japanese patent at you that you would not have found because you weren't translating it, right? So searching is useful for startups, and it can help. I have a couple of clients who do searches, but they don't do it before filing the provisional. They do it before paying for the expensive non-provisional, right? And I think they come to break even doing that. The quality of searches can be very, very widely ranging. An inexpensive search is $500 or $600 maybe. But that gives you something, right? The problem is that you have to realize that to do a search, you have to write a description, maybe some claims that the searcher is going to use. So that takes somebody's time. After you get search results, you get, a dozen patents. And if you haven't attended a seminar on how to understand the patent, you'll go, oh my gosh, we're doomed, right? And it might be that those patents or patent applications really impact you or not. And it takes either a good eye or understanding of the law or a patent attorney to decipher that search results for you. So analyzing the search results are often more expensive than the search. High quality searches. So I do a really high-end search when I'm about to cert patents, right? I've got a set of patents that I'm going to sue somebody on. I want to make sure there's not prior art before I spend tens, hundreds of thousands or millions of dollars. I'll spend $7,000 to $10,000 on a search, right? And the people who do those will be experts in the field with PhD level people, and just gives you an idea of what kind of range in search. They will search all across the world in multiple languages, and that's what you do when there's big numbers, on the table. So that's searching. Okay, next question.
Charles says 100% Steve, do you have IP is one of my top 5 questions I ask every startup looking for funding. Thank you, Charles. And go ahead.
Yeah. So I'm also I'm a venture partner at a VC firm. If you look on my LinkedIn profile, you can see that. We focus on kind of A round, B round companies. And we look at IP. I mean, that's having me on the decision-making committee makes that important. And it not only reflects on the value of the company, but it reflects on how much the founders have their act together, right? If they answer the question, like, what are you going to do about competitors? And they say, oh, we have a provisional application filed. We don't have to worry about competition. They're out the door. I mean, as an investor, I'm going to say no, because they don't understand. They don't understand the competitive market. That provisional won't be a patent for years, and they will either be dead or not by then, right? So, Steve, that's an important thing.
When you say they're out the door, not because of that only, it's just you don't check that box, right?
Yeah. I think that,
right?
Yeah. So they're out the door not because of the IP, but because they're understanding the competition, right? If they think that a provisional is going to protect, if they don't have to worry, if their only answer to the question about competition is that we have a provisional filed, that isn't a reflection of their, I mean, it's great they have a provisional, but it's a reflection of where they think, what they think they need to do to succeed in the market. They need
So
to beat the
it's
competition.
it's a judgment on their skill set and
Yeah.
what are you saying?
Yeah, it's a judgment on their understanding of what they have to do to beat the competition in the market.
But
They need to have other reasons.
isn't that a bit extreme? I mean, if they make that one mistake, we just gotta kick them out to the curb, or is there some other
Well,
alternatives
you
to
are,
help them understand where they're gonna go and what's the
yeah,
process to get to that level of thinking?
I talked to another VC, who's a woman-owned, a woman-founded VC firm. They're great. A while ago, and she said that last year they made 2 investments and they saw 1,600 pitches.
And
So yeah, having a idea, not having a good strategy towards the competition is a serious mistake. That they would have to be really trainable or really have something else that was really outstanding in order to get past that first threshold. Yeah, that's kind of one of the things. If people don't understand the competition, to me personally, that's and it's not, now we're not talking about IP here anymore. We're talking about, what is gonna make, a company something I'd want to put my money into. And that's one of the factors. Yeah.
okay, well, just for the record, my group, we don't kick you out. We don't kick you out the curb if you made that one. We will love you a bit more,
Go with Jordan.
and then we'll kick you out the curb because Steve told us to do. But fundamentally, if you don't have the right patent strategy, it doesn't mean you're out. It means you
Oh,
need some more work.
And again, they're not getting kicked out for not having a patent strategy. They're getting kicked out for thinking that the patent strategy is why they don't have to worry about competitors. I would kick them out because they don't have a reason. They don't have good reasons why they're going to beat their competition.
Okay, well,
Right?
we're on the same page. Then we're on
Yeah.
the same page. You got it.
Yeah. Yeah. It's not the patent strategy. The patent strategy can be fixed. It's I don't know anything about my competition, or I don't have any advantage over them that I can articulate. Then that's a problem.
Got it. That's great. Thank you, sir.
Okay, great. And a lot of our attendees are wondering about the chat being saved. If anybody wants the chat for networking purposes, I'm glad to send it to you. You can DM me on LinkedIn or anything, any way that you have connection with me. So don't worry about that. This is your last chance to submit a question. I have one here. Is it a good strategy to have one of your other companies own patents so that it can't be copied?
Okay, I'll answer that. So if you're a company where you're going to have investors come in and invest in you, angels or VCs, they want the IP to be in the entity that they're investing in. They'll insist on that. Right.
Say that again. Say that one more time, Alan.
If you are a company that's going to take VC investment or angel investment, the smart angel or VC will want the entity that they're investing in to own the IP.
That
And
makes sense.
the reason for this is, what if the IP goes somewhere else, or if everything goes to hell in a handbasket and the IP is the only value left and it gets sold for a few $1,000,000, the investor wants a piece of that, right? I see another question about from Nancy. She's asking about employers and employees. So and she's saying, is there a difference between employee and attendant 1099 contractor? It depends on the state. Depends very much on the country. So a 1099 person, if they have a contracting agreement, there should be a IP clause in the contractor agreement. It's not so much a function of whether they're an employee or a contractor. It's a matter of what their agreement said. And a good example is Upwork. If you hire somebody to do your company logo on Upwork, there's a checkbox that says, I am going to want to own the IP that's developed in this, I'm paying $50 to somebody to give me a bunch of logos, right? I want to own that IP. You have to check that checkbox. If you don't check that checkbox and somebody develops a great logo for you from Malaysia and you start using it and a few years later, it's your company's core logo. Well, that person in Malaysia still owns rights to that logo. They produced it for you, but so pay attention, even especially when you're doing contractors, owning that everything that's produced, your website, right? It's not owned by the website hosting company or the website developer. It's yours. Okay, that has to be in the agreement. So those are places where IP can catch you. All right.
Okay. Let me ask, two more questions came in from Charles and William, both on provisional. Can we explain what a provisional is and why it has little value?
Okay. So again, Jennifer and I will get you another presentation that dives into this. But a provisional application, there's in the US, there's something called a provisional application, and it has two purposes. One, it allows you to do a filing before you publish something or you use something publicly, because that can cause you to lose rights. And we're not going to go into details there. That means that if you have a white paper or a deck or a presentation you're going to do to a public group, if you file that as a provisional first, it gives you a filing date, and you still have the rights to file, for example, in Europe. If you make something public, that is a bar against getting a patent in Europe. You have to file an application before you do the public use or offer for sale. Okay. The other use of the provisional application is to get priority rights. In other words, you're going to disclose something in that provisional that's key, that's really important. Okay. The advantages of provisionals is they're really inexpensive. You can take a white paper and put a cover sheet on it and send it in, and you might pay $120 filing fee. That's pretty inexpensive. And the problem, there's tons of problems with that. Okay. It may not disclose enough. It may have parts missing. So your later claim, it doesn't support claims that you have in a later patent application. The provisional only lasts for 1 year. And in that 1 year, you have to file a non-provisional, a full patent application, claiming back, referencing that provisional, saying, I claim benefit of this provisional application. If you do that, you get credit for the provisional filing date for only what's in that provisional application, right? So if it's too thin, if it's a 4-page document that's high level but doesn't have any details, it's probably not going to support, the claims that you want to make later, because whatever's in the claims has to be supported by the specification. So we got some examples from big companies like X and their huge long claims. Well, every one of those phrases, as they added that material to their claims, had to be supported by the specification as it was originally filed. And if that was a provisional that wasn't meaty enough, that's a problem. All right. There's some tools now that I'm looking at that are good for getting provisionals. And I might, maybe in the fall, Jennifer and I will put a presentation together on using AI for patent drafting. Once I get more of a feel, I'm definitely using it for proofreading now. It helps, and I think it's going to become useful. But it will have, we'll use it for provisionals, crank something out, spew something out, and file it. I do provisionals in the following way. I will, on a fixed fee, $2,500. I'll do an interview with an inventor for 1 or 2 hours, discuss their invention. Then I will write them a full set of claims and maybe a summary and some block diagrams. And then I'll take the claims and make an outline, and I'll hand that over to the inventor. And I'll say, you fill in this outline. And so sometimes that works, depends on how good a writer the inventor is, right, or the founders. And then we'll file that as a provisional application. The reason for taking that approach is that way we've at least made sure there's a set of claims that's fully supported by the application. And that overcomes some of the real dangers of filing provisional applications that don't really have enough meat to them. So when I write a provisional, unless it's a PowerPoint deck and we're just filing it to get before a presentation, right? When I file a provisional, it at least has a set of claims. That's not a requirement right now, mind you, but at least has a set of claims in it that are supportive. All right.
Okay, could you disable your screen share while I go to the next
Yes.
question? Okay. William, thank you. Same subject on provisional. Patents are in provisional for years, and the exit horizon for a company is only a few years. Should special tactics be used? Are there any concerns?
Yes. This is it. So the VC firm that I'm involved with, our saying is that we invest with an exit in sight. Okay. The same thing should happen with if your patent attorney doesn't ask you what your exit plan is, they're missing something, right? So I might have a startup and their goal, I had a good one last year that sold to Apple. It was the year before, whatever. And they knew who their potential acquirers were when they started the company. And when we wrote patent applications, we intentionally wrote claims that would be valuable to those companies. Okay. So we have some set of features. We say, well, what if we were Apple? Well, how would we integrate that into the iPhone and our other computers and services? And we wrote claims that looked exactly like that. It was the great technology of the startup company plus what Apple does. So that when Apple comes along now and says, I want to buy you, and they're doing all their due diligence and they look at the patent application and they say, yeah, that's it. You know, this is exactly what we plan to do, right? And that makes IP more than just a checkbox, right? We're going to all learn this. We got to make it. We got to get a rhyme to this. And somebody write me some melody for this to make the IP more than just a checkbox. Yoshi could sing it, I'm sure, right? So you want to have IP that covers your core features. And as you grow that patent portfolio, some of what you're going to do is say, boy, Facebook, no, I don't remember Meta. That's my client, so I can't use them as an example. NVIDIA is going to buy us. They have lots of cash. How would we write this claim if this feature was going to be bought by NVIDIA? What would make it valuable to them? And the reason your question brings this up is NVIDIA will have the money to enforce that patent 15 years from now. The magic time for a patent is usually about 10 years after it's originally filed, because that's long enough to know they were first. And it's long enough for everybody else to want to do that part of the market. The market's caught up with the ideas that are in the patent application. And so, when you see patents litigated, they're usually at least that old. Okay, folks.
Okay. Is it possible for you to answer the same question with patent pending?
Answer the same question with patent pending. Well, once you file provisional or non-provisional, you can say patent pending if you're describing what's in that document. And so that's nice. It's a good thing to say. It's something you want to have on your slides and on your product, right? The patent, as Reebok showed us, a patent, what's covered by the patent and the claims, can change quite a bit during the prosecution, right? So and literally, there are times when I change claims because I see what a competitor is coming out with, right? So it's like we have a set of claims, we have 10 claims, and they are at our core technologies, and we have a big specification, 80 pages. We described a lot of stuff in, okay? And what we're claiming now is only a small part of what's disclosed. A competitor comes out with a feature that kind of looks like what we're doing, and we describe that in our specification because we described it, and hopefully also the provisional, right? We described it in our specification. We can now amend our claims to add the 11th claim that reads right on what the competitors came out with. And I do that all the time. Yeah, that's the fun part.
Okay. Margaret wants to know, if you intend to build a novel digital product, how do you know when filing for a patent is vital for securing long-term sales or of this theoretical product.
Yeah, of the product. So sooner the better. You can file provisionals, $2,500. Startups will typically do a bunch of them in their first year because they're constantly changing. Sometimes they'll turn 90 degrees and go off in a different direction and throw away the first provisional. And they'll be glad they spent 2,500 on it and not 20,000. Okay. So get a filing date. Write it down and get a filing date. The provisional gives you 1 year, right? Hopefully within that 1 year, you've built traction, you've got investors, and now you can afford the non-provisional, right? You look back at the provisional and say, well, was that anything close to what we're doing now? Right? And if it was, then you claim benefit of it and you use it. It will be, if you decide only to file in the US, you can avoid publishing your patent application until it actually issues as a patent, which could be a few more years, right? If you file outside the US, you have to publish. And so it'll publish roughly 18 months from the provisional filing date. And by then, by then, all those cool features are going to be in your products anyway, and people see them. So I'm not too worried about keeping things secret. So I'm more worried about, and I have seen big competitors with filing dates, a couple of weeks apart, 10 days. It's like, whew, I dodged a bullet.
Thank you. I just had anyone come in, but just quickly, Frank, I am developing solutions in generative AI. Please, how do I go about getting IP?
Oh, wait. Where'd it go? What was that? Could you say that again?
Sorry.
I was reading it and listening.
If someone is generating products with AI, generative AI specifically, how do they go about getting IP?
You talk to your patent attorney. I think Rupert would probably agree. Depends on exactly what you're doing. So my example a few years ago, MIT announced they had an AI that was developing battery chemistry, right? For lithium-ion batteries. And I'm like, oh boy, if I was an examiner, I'd just stomp all over that. Like, who invented this? Your tool or a person? And it will be 20 years, I think, before inventorship in AI has really worked out. It's more an issue right now in copyright. If a picture is 100% AI generated, it's not copyrightable. If it's 10% human and 90% AI, I don't know. If it's 50-50, none of that's worked out yet. Okay, so who knows? It really depends a lot on how you're using the AI. If you're an AI company, definitely. 80% of the patents I do are software, and right now half of them are AI related in medical, in e-commerce, in security, all kinds of stuff. AI it touches almost everything we're doing.
Final question from the attendees, and then we will move on to wrapping it up with our panelists. Chris wants to know, what would you recommend for an early stage company setting a valuation during that time to attract investors for growth stages?
Okay, so if you're really early stage, you're going to do some sort of safer convertible note, which will avoid, it'll have a cap in it, but that will avoid, there's many reasons you want to avoid setting a price for the company, a whole different seminar. Part of that is so that you can give shares or options to employees without giving them tax nightmares. So that's not purely an IP question, that's a corporate question. But people get around it using SAFEs, Y Combinator's. My last call was with the Y Combinator company, and so I knew exactly what kind of investment they'd had, because they use a standard investment vehicle that Y Combinator uses. So I see another question.
Go for it. It's Charles.
Yeah.
Thank you. How do you define 100% created?
Oh, you mean by I was talking about like an image. So people were trying to copyright images that were generated by an AI. The pixels of the image were generated by an AI, and a human wrote the prompt. of very unsettled law on what's going to happen there. Somebody's asking, oh, that's not so much of a question.
Okay, at this time, let's open it back up to our other panelists to ask Dr. Colby questions.
Well, I don't have any specific questions, but the whole topic of doing evaluation for a startup or a new venture using IP is kind of new to me, or something I haven't had too much exposure to. So, the question you asked about how those patents for those unicorn companies may have contributed to their valuation early on. That's got me thinking as like I should go back and take a look and see if it actually did make a difference. But do you have any other anecdotes about how patents may have affected the valuation of a company that startup that you're working with?
So I have a couple of specific cases where two companies were doing exactly the same thing. And I know that in one case, it was a $380 million exit, and the company was less than 3 years old. And the IP, I know there were two big factors in the exit. One of the companies got bought, the other one went nowhere. Okay. The two factors that were, the IP made a difference, and the personalities of the CEOs made a difference. My client was a really nice guy, and people wanted to work with him, and the other person was the opposite. And it was a big multinational company that did the purchase, and I am sure that the personality and the quality of the person that was the CEO made much more difference than anything else in the purchase. But the amount that, and the value they were bringing was pretty closely tied to the IP, so it was good. And again, every round makes the IP more than just a checkbox. It should be in your starting in your A round. It ought to be something that is woven into your pitch, a clever way that builds the value in the mind of the investor. And that's what the IP attorney's job is in most cases.
Okay.
For this startup company, right? I have clients that are 40-year-old and they're family businesses, and they use IP to pound on their competitors, but they're not. Yeah, it's different. Then there's a different strategy.
Rupak, on my side, I did work for an identity company, and they had a lot of IP and gave them differentiations against meeting government specifications, against being compliant with some market segment for entries. And it did make a difference in the value of the company in a couple of ways. First, the IP prevents others from entering the market, so that gives you a little bit of a value in the investor's mind. The other one, there's organizations out there that have the scientific methods to look at your IP and how you commercialized it, and the potential to commercialize it further over a function of many things. So that's a second, and that's a real life example. It did make a huge difference. The third one is we looked at several companies, and one of them we invested in. I cannot say the name because they're about to exit. Yes. They had some geolocation IP, and that allowed them to differentiate themselves significantly. It didn't stop others from entering the market, but it allowed them to acquire the market faster, quicker, easier, etc.
Okay.
So it does make a difference. However, the other side, which I mentioned earlier, somebody comes in with a patent attached, like that doesn't make you more valuable or less valuable. You said something about defensibility, which is great, which is what Steve alluded to, but then you got to attach a value to it. If it doesn't commercialize, then it's a paperweight.
Yeah, it's wallpaper. Sometimes literally, right? You put it up on your wall.
Oh, yes.
It's wallpaper.
Yes.
Doing the Yeah, and sometimes people come to me with these patents, and the first claim is 2 columns long. And if you understand what that means, it means it's incredibly narrow. Somebody would have to work really hard to infringe that claim. And the inventor will come, or the founder will come to me, I got this patent, it has everything we do in it. So somebody would have to do everything there in order to infringe. Okay,
Mhm.
it's incredibly narrow, and people
Right.
don't get that right. So I will talk about that in my seminar on understanding the patent. But I think that, I have a few dozen patents of my own, and inventors, I know a lot of really creative, inventive people. The idea is like 3 to 5%. The other 97% of a successful startup are the people, the personalities, and the work. And that's where the real value is, as Jordan was saying, taking that and building value from it that's the hard part, right? And we're just one piece.
Got it.
Yoshi, do you have a question?
Yoshi has left the room. He's acquired enough seed during this amazing webinar event. Thank you so much. And
Steve and Rupak, I got a question that you can answer in 3 bullets each.
Yeah.
What are the top 3 things we should not do when we're tackling patents? 3 bullets, not paragraphs, 3 bullets.
3 things you should not do?
Yes, sir. The top 3 things you should not do when you are tackling patents.
You should make sure you own your patents.
I said not do. The
Wait too long.
biggest mistakes you should avoid.
Yeah.
Wait
Well,
too long.
I can think of just one. I mean, that always bothered me about patent attorney or patent law firms. One is the startup, the inventors should not use a patent attorney who doesn't want to have a in-person or a video conference invention disclosure meeting and get real details on how the invention works and takes the time and effort to really make an understanding. There are some who will just take the invention disclosure form, like a written description from the inventor, and just use that to draft a patent application. That's a big red flag for me.
Why is that, Rupa? Give us a bit more juice.
Well, I mean, just because the written description from the inventor is going to be high level, it's going to be an overview, it's going to be written in a certain way that certainly conveys what the invention is, like at a high level. But for a really good patent application with claims that capture the novelty and is really worth its salt, is to have a 1 or 2 hour invention disclosure meeting with the inventor, where the patent attorney is asking very specific questions about the novelty and drawing lots of diagrams and really getting involved in understanding what the invention is. And a lot of some patent attorneys don't do that. They don't go through the effort of understanding. I do. I have a feeling Stephen, I'm sure, does. So the don't part is don't use a patent attorney who isn't asking for an invention disclosure meeting with you up front to get all the details.
Yeah, I'd go a step further, and I'd say don't use a patent attorney who doesn't want to know all about your business. Because if the patent is going to have value for the business, they need to not only understand the technology, but the marketplace and why, what you're telling investors. The patent attorney needs to know that in order to write claims that really make it valuable. So don't wait too long. File early.
Yeah, that's another one, right?
And don't trust your co-founder is going to sign his invention to the company 3 years later without a written agreement.
Get it out of the way, basically.
Get a control. Don't lose control. I have seen cases where a company has raised over $10 million and the CTO never signed that invention assignment agreement. And all the CTO turns around and says, I want 50%. And it
Yeah,
goes to
those
their-
assignments need to be filed right
yeah,
when the.
own your IP. Don't forget to make sure you own your IP as you're done.
And the third one?
That was 3.
All
I
right,
don't
File
know.
early and often.
you get off the
Know,
hook.
know the business. Yeah.
I agree with Steven's last 2. Do it early, don't wait till the last minute. And yeah, get that assignment of ownership thing done like when you actually file the patent application. That's important. Otherwise, it'll get real messy later on, potentially. So,
All right.
All right. I just wanted to say thank you, Dr. Colby, Jordan, Rupak. I know I learned a lot. I am sure the attendees have given their responses to us in the chat. Thank you for participating. And I look forward to hearing your feedback. And that's a wrap.
okay,
We're gonna
thanks,
end
Jennifer.
the
Bye, everyone.
meeting.
I need to head out of here. I'm in my office. It's getting late.
Oh,
Thank you,
So,
Rupak.
take
all right.
care.
Bye-bye.
Bye.
All right, Jordan.
Take care,
Good to
Jan.
see you again. I
Same here.
am in the city pretty often, so
I saw you just a week ago.
ah,
Some
Is that-
event and I bumped into each other. I forget which one it
Oh,
was, but
it might have been one of Casey Wisdom's events.
you know how it is. It's all
I know.
bumping together these days. You don't know. But I saw you at least within the last month. I said hello, you know,
Yeah.
you a
Or
little
at
shoulder.
I go to Angel Launch a lot. So
It was an Angel Launch or it was the Bill Berry Ignite.
yeah, could have been
Yeah.
Ignite.
We're missing it right now, you and I.
Yeah, I had a meeting, a social thing in Sacramento. I was like, okay,
Yeah.
I'm not gonna make that.
We can't do them all.
I know, it's fun.
It's just a lot of them. You
All
have
right,
a good
dude.
night, sir. Bye-bye.
Talk to you later. Bye.